Today I visit with Sam Tate on the UK Economic Crime and Corporate Transparency Act.
Hello, everyone. This is Tom Fox back for another episode, and I'm absolutely thrilled today to have with me Sam Tate. Sam's a partner at RPC in the United Kingdom, and you're in for a treat because I'm in for a treat. Sam, first of all, welcome. It's been way too long.
Tom, it is a real pleasure to see you. I'm delighted to be back on your podcast.
Sam, I was wondering if before we get to the subject matter of our podcast today, which is the Economic Crime and Corporate Transparency Act, you could remind our audience of your extensive background in anti-corruption compliance, financial crimes, the law world, etc.
Well, I'd be delighted to, Tom. Thank you for the opportunity. So I'm head of white collar crime here at the law firm RPC, which is an international law firm, about 500 lawyers and foreign offices, international network, and so on. My own history is that I was head of anti-corruption in-house at a large oil and gas company, BP, for a number of years. I worked on the monitorships for HSBC and Credit Agricole, and since being a partner of RPC and running our team here, I've negotiated the last two deferred prosecution agreements in the UK and been one of the only two monitors we've had in the UK for a deferred prosecution agreement. So my experience is kind of a mixture of banking, corporate deferred prosecution agreements and investigations. I did the Wirecard investigation over allegations made in relation to journalists at the FT, for instance. So it's kind of broad-ranging financial crime practice, but we pay particular attention to policy issues and new laws that are coming through. Those are things that I'm really fascinated by, and that will be part of the topic, the impact here on international companies, and particularly US companies.
Sam, could we turn directly to the new act and what it is, what it does, what's new, and why this may or may not be a game changer for the prosecution of economic crimes in the United Kingdom?
Well, you sit around and you wait for big changes in the corporate criminal law for years. In this case, about 50 years. And then the two biggest changes, they come along at once in this bill. So I think it's got more than a kind of UK interest. I think it ought to have some global awareness now that the act has been passed. And there are two things that are going on here, Tom. First of all, in the UK, we don't have your very sensible way of holding companies to account. So we don't have vicarious liability. We've got something called the identification principle, which means that it's got to be the directors who are involved in the criminality. Well, that's changed, or will change at the end of next month, the end of December. So senior managers are going to create that liability for companies. And so the number of people who can create that liability have gone from a handful to maybe a few hundred in some organizations. And that's a big change in our law. And the second area is a new failure to prevent offence in the area of fraud. And so it's a bit like a kind of UK bribery act offence, but for fraud. But Tom, as you'll know, there's much more fraud than there is corruption. I don't want to get in trouble with your listeners by saying that, but if you think about it, and mis-selling and greenwashing and other things, it makes sense that there's a lot more of that type of fraud out there. And so it should have a big impact. And there is a compliance program that will go along with that, which companies will have to implement if they want a defence, and it's the only defence.
Are there any other key principles, or key examples that we should discuss at this point?
Well, I'm happy to take you through kind of the points one by one, but I think what your listeners ought to be aware of, Tom, is that these are changes which are coming in now or very soon. And so, there is a really kind of short window of opportunity for them to get thinking about fraud in this different type of way, and I'll move on to that, and to start re-examining their programs to take into account these changes in the law.
Well, now that you've identified a problem, how perhaps might you suggest we think about an answer or response? You mentioned a compliance program. If a client comes to you either from the United Kingdom or perhaps even from America, says, Sam, what do I need to do now, either differently or with a different focus? How would you counsel them?
Well, I'd probably say this, Tom. I certainly would start by just explaining the offences a little bit more. So, the failure to prevent fraud offence is about, it's not about the fraud which you and I would think about normally. It's not about expenses, it's not about stealing, more or less. You know, this is about fraudulent misrepresentations. This is about putting statements in your sales materials which are not true, which bring people in to buy your product. This is about lying about your green credentials. This is about misstatements in your accounts. So whenever you've got a class action there, you can also have a criminal action in the UK for failing to prevent that fraud. I was going to come on to a couple of examples, Tom, but you brought them out of me early. So it's first of all, you've got to change the way you think about fraud. And then in terms of the practical things that you'll be doing, well, your program is probably about people stealing things from you. You know, that it may sit within financial crime, or it may sit within security or audit. But you're going to have to start thinking, well, what do I need to do in my program? And so you'll be familiar with these, very familiar with these ideas, Tom. But you know, who is in charge of my tone from top on fraud? You know, have I done a risk assessment on this type of fraud? When did I do it? Most companies haven't done it, to be honest. And what am I doing on third-party risk management? Because my third parties, just like the Bribery Act, can create this liability for me, this criminal liability. And actually my subsidiaries can, which is kind of expansion of the Bribery Act that we have here. You know, what controls have I got in those subsidiaries around their kind of marketing materials, around their accounts, around their misstatements and those sorts of things. Plus monitoring and, of course, training. So what does my program look like in these areas? And I've got to say there's a kind of big gap between where companies need to be in a few months' time and kind of where they are now. And that the guidance, which I've seen an early copy of, it does look a lot like the Bribery Act, but you know, most companies are just not implementing these controls in this kind of fraud area. And the fraud, I should say, goes well beyond, in fact, even mis-selling. This is about fraudulent trading. This is about obtaining services dishonestly, false accounting. There are tax offences in there as well. So you know, you've got a broad range of these UK fraud offences. And if any victim of those offences is here in the UK, or you're here in the UK, then you're caught. You know, and so there's this kind of broad extraterritoriality, which you guys, of course, in the US are very used to. But for us, is a little bit unusual.
Sam, who enforces this act? I know there are several different enforcement agencies in the United Kingdom, but could this even extend to a private cause of action by an aggrieved individual?
Well, I think private prosecutions are a real possibility here. And so if you're a company, looking from the company's perspective, you'll have probably class actions, and then you know, the company itself may be investigating the wrongdoing, but an aggrieved NGO or third party may wish to bring a private prosecution. Those are unusual still in the UK, but yeah, it could be the Serious Fraud Office. They would be the relevant prosecutors normally for this offending, or it could be an individual, albeit the prosecution would have to occur under something called CPA guidelines. So you'd have to act properly and as if you were a prosecutor for the government.
Do you feel like at this point the United Kingdom prosecutorial services has the expertise to prosecute significant financial crimes under this law, or will you suggest they bring in additional resources?
Well, so we've had a change in leadership over the last couple of months here in the UK for our Serious Fraud Office, and Lisa Rosowski has departed, and Nick Fgrave has arrived. And when you listen to his statements, he is talking about adding another 135 investigators or prosecutors to his total number here in London. And I've heard statements, not directly from him, but from others at the SFO about how important this legislation is. They've been pushing for it and they want to use it. So there's the intention there. They are growing the resources there. And I think that they do have this capacity to go after big cases, albeit perhaps not as many as you do in the States. It'll come as no surprise. But, you know, big cases they have pursued in the recent past, you know, relatively recent past, Glencore, Rolls-Royce, and you've seen Tesco's, Standard Bank, and others beforehand. So kind of a smaller number, but still some kind of significant names. So there's the intention there. They are kind of tooling up around it, and they have a history of with some success in this sort of thing. I don't think they can be. As to your point about, I do want to answer it, Tom. Do they need to bring in other people? Well, they're constantly asking for secondees, and they have had advisors in and groups. I would say yes. There needs to be more funding into the SFO, and that should extend to bringing in expertise from the private sector.
A little bit earlier, I asked you about key provisions, and you started to tell me those, and then I took you down a completely different direction. Could we circle back and really just ask you to walk us through what you see the key provisions of the Act for our listeners?
Sure. Well, if you don't mind, I'll start with the failure to prevent fraud offence, and then I'll go back to the identification. So the failure to prevent fraud offence is a strict liability offence. So when you, the company, or your associated person, which would be a subsidiary, or an employee or an agent, commits a fraud for the benefit of the company, then the company commits an offence, whether or not it knew of that wrongdoing, the directors or others knew about, or whether or not it approved of it. So in that way, it's a strict liability offence. And the only defence that you have is that the company has in place a reasonable set of procedures to prevent that wrongdoing. And those are those 6 principles which I started talking about. Now, we don't have the statutory guidance yet. I'm told it's going to come out in December, and we may have a couple of months to look at it. But we believe it will then be enforced from about somewhere between Easter and the summer. So the key provisions here is strict liability, and then you've got this one defence. So in that way, it's quite straightforward. Now, I also add this because it's important, that the law only covers large companies, and the definition there will be of interest to your listeners. So it's companies that satisfy 2 or more of the following: a turnover of more than £36 million, balance sheet total of more than £18 million, or more than 250 employees. But look, that's every Fortune 500. So all of all of your larger companies, or any large company in the world, is going to satisfy those requirements, as is a subsidiary of any of those companies. So all of those kind of registered offices of large companies here in the UK. What I might add is that it does take out the vast majority of companies, which would be smaller companies, small to medium sized enterprises. But in terms of people who are often making investments in their compliance program, it will hit every large company and partnership.
So let's explore extraterritoriality a little bit, because that is, I don't want to say one of the most controversial parts of the U.S. Foreign Corrupt Practices Act, but it is a part of the law that I think catches many outside the United States unaware. And so we've had prosecution of UK citizens who were not in the United States, yet were extradited to the United States and had to stand trial and were convicted. Do you see that type of extraterritoriality, or is my wife, who is English, now subject to this law literally wherever she lives across the globe?
I think, well, I'm sure your wife isn't busy defrauding people, Tom. So she has nothing to worry about. But it has quite a broad extraterritoriality. But this is a corporate offence. There are no individuals who would be found guilty of a failure to prevent fraud offence. So this is about companies. You're not going to see, perps shipped across the Atlantic this way for this failure to prevent fraud offence. But the way in which companies in the US and globally are going to be caught by this is that the victims of this mis-selling or these misstatements of this fraud will be here in the UK. Because we work in a global economy, and things are sold globally, and people invest globally, or buy their bonds globally. And so there's always going to be people in the UK who are investing or buying in some way. And so there'll always be UK victims. And that's how this works. It's not like your US FCPA where there's transactions in dollars. It's not like that. It's not about so much about email communications. It's about this victims piece, and it's about how or some aspects of the crime being committed here in the UK. And that means there's a bit more to that in substance than it would be under the FCPA. But it has this quite broad extraterritoriality. So what we're expecting is that global companies, and particularly ones who are doing things in the UK, will be looking at this event, and will be looking at the guidance and what requirements they need to meet now or eventually.
Sam, the title of this new law is the Economic Crime and Corporate Transparency Act. I'd like to ask you to focus a little bit on the second phrase, the corporate transparency.
Sure.
Is there anything new there that either puts an obligation on the UK government or puts more obligations around transparency on corporations?
Yes, there's a ton of stuff, Tom. So it's about 300 pages long. I wish I brought a copy with me because it's like a book of a law, and it's everything to everybody. So anybody who wanted a change in the criminal law for the last 20 years in financial crime has kind of found it somewhere in ECTA, this new act. And for the companies who are operating here in the UK, it really changes how the company's house operates. So company's house until now has essentially been a giant library where you might put your book about your company and its data without it being checked and without having to provide information around other beneficial owners and so on. And that's all changing with ECTA. So you've got the company's house acting in, I would say, a much more responsible way, and you've got companies having to provide more detail. Now, how effective that will be will depend on how well it's policed on and how well that's funded. But certainly the aim is to have much more corporate transparency than we've had hitherto.
So in the United States, at least, when people think of fraud, they think of economic theft of money, however that may be accomplished. Obviously, the Association of Certified Fraud Examiners focuses on the loss of monetary benefit to corporations literally across the globe. Earlier in this podcast, you delineated multiple types of fraud that were not simply theft of money. You mentioned greenwashing. You mentioned, I wouldn't say sales puffery, but sales marketing material that may not be accurate. It could be representations to shareholders. And it really, I say all that as way of introduction when people hear, well, there's a new omnibus or all-encompassing fraud act in the United Kingdom, they're going to pick up the phone and call their fraud examiner and say, oh, there's this new law.
Yep.
And in listening to you literally over the past 20 minutes, it strikes me that conversation, a fraud examiner should be a part of that conversation, but it's a much broader conversation within a corporation. If you were going to sit with a corporation after you explain to the CEO the significance of this, would you sit with the chief compliance officer? Would you sit with the chief financial officer? Would you sit with a CCO or perhaps some other group or perhaps all of the above?
Well, Tom, I'm happy to sit down with anybody. And you also know that I think a certified fraud examiner should be a part of every discussion. So in that they bring a kind of huge benefit and a wealth of experience typically to discussions in financial crime. But it's a bit like ESG, Tom. So where does it sit in your organization? Does it sit under the chairperson? Is this CCO discussion? Is this a kind of head of financial crime discussion? So who's able to impact things on the ground? So personally, I think in the UK, a lot of this is being dealt with by chief compliance officers and maybe by heads of anti-bribery, because the guidance, so the requirements, are very similar to the Bribery Act requirements, and so that's where that centre of excellence and expertise is in that group. But if I can just I just want to be clear on what fraud is included. So fraud by false representation, so that's lying in order to better your position or make worse somebody else's. Fraud by failing to disclose information, fraud by abuse of position, so that's your kind of trustees, partners, perhaps others. Participation in the fraudulent business, it's pretty broad. scamming and the like, obtaining services dishonestly, false accounting under the Theft Act, false statements by company directors, fraudulent trading, which is about when you trade and you shouldn't be trading because your company is in fact insolvent, and cheating the public revenue, which is a common law offence. So it makes the bribery act really simple, Tom. But bribery is very simple. It's simple. You've got Section 1, which is offering to pay somebody a bribe. You've got Section 6, which is offering to pay a public official a bribe. And there you go. Those are your predicative offences. But this, you can see, is a real mix. But it is, as you say, primarily about defrauding another person. And most of the use cases that we can think of are in the misselling and misstating category, and not in the theft category.
Too bad this act wasn't around when the crypto exchanges were in their heyday. A lot of people could have utilized such a remedy.
But it's kind of the sad nature of laws that they're always behind. But if you look, the UK economy is not going quite as well as yours in the US, unfortunately for us here, Tom. But a lot of countries and economies are entering a more difficult period. And so we will have criminality. We are going to have people misstating things to their investors and to their shareholders and to their buyers of goods and services. And because time to time, so there will be more incentive for those people to act fraudulently. So I think this is going to get quite a lot of use. As I said at the beginning, I think there's more fraud in the world than there is bribery. Your listeners will email me and say that's not true, Sam, and they're welcome to. But I put it out there as a hypothesis. And if that's true, then this act would have more utility.
Well, I'm going to crown your hypothesis as truth and fact, because every year I read, or every 2 years I read the report to the nations from the ACFE, and bribery is actually a subset of fraud, and there's $3 trillion lost to the world's economy annually for bribery and corruption. I think fraud is at least double that and maybe more. So absolutely, fraud is a much bigger problem and picture for the world's economy. Sam, unfortunately, we are near the end of our time for this episode. But before we leave, I wanted to ask you if our listeners wanted any more information on yourself, the law firm, or really any of the topics we've touched on, what might be the best place or places for them to go?
Well, Tom, they would be very welcome to contact me at RPC. sam.tate@rpc.co.uk is my email, and I'm on LinkedIn regularly. I'm a regular contributor to a number of different groups. They would be very welcome to contact me or our firm to talk about what they can do. We've produced a number of articles which are online with kind of use cases, practical scenarios to kind of talk people through in very kind of layman terms what's coming and what they can do. And they should stay abreast of the news. Either through us or through LinkedIn, or I'm sure there'll be things in the FCPA blog. But they need to get ready. There's only one defence, it's the Federal Fraud Offence. The guidance is coming out. They should be doing gap analysis, thinking about what resource they're going to need to apply for 2024. Anybody's doing a plan now, and they've got a part of their own file is in the UK. Please get in touch. Please give some thought to how you're going to deal with this in your budgets and resourcing for next year.
Well, Sam, I wanted to thank you again for taking the time to visit with me. We both agreed it was way too long between sessions, so I hope we can continue this conversation on a little more regular basis.
Well, I very much look forward to that, Tom. And look, thank you so much to having me, and thank you to everybody who's listening. I hope it's been helpful.
This is Tom Fox again. Thank you so much for listening to this episode of the award-winning FCPA Compliance Report. If you would like more information, we've linked to Sam's contact details in the show notes. If you've enjoyed this podcast, I hope you'll subscribe, rate, and review wherever great podcasts are listened to. The FCPA Compliance Report is a production of the award-winning Compliance Podcast Network.